Good job. Senator Wieckowski, we will call you back for the fourth and last item in the special order dealing with mandatory binding arbitration, SB 1241.
Thank you, Madam Chair. SB 1241 focuses in on two of the worst kind of clauses that can appear in a consumer or employment contract. The choice of venue clause that requires a consumer to go to an arbitration or to a court in an entirely different state. And number two, the choice of law clause that intentionally picks what state's law governs the arbitration, thus deciding that the rules are, in a nutshell, to the disadvantage of the consumer. A California consumer and a California employee should never be forced to travel to a different state to exercise her right to litigate or obligation to arbitrate a claim. If you're selling goods or services in California or employing Californians, you should not be able to force all our dispute resolutions to take place in Florida or Delaware. Just the cost of travel alone prevents California consumers who are not armed who have been harmed by an illegal practice from seeking compensation. This is especially true when the amount in controversy is not very large and where a business can get away with nickel and diming consumers who cannot afford to do anything about it. The only reason a business that wrote the contract would want the laws of some other state to apply is to the disadvantage of the consumer, because that state's consumer protection laws are weak. Senate Bill 1241 ensures that a California consumer who purchases goods or services in California or works in California has her dispute resolved in California using California law. And with me, we have Tara Zoomer, who's a former employee at WeWork, and is that Ramsey? Yes. Yeah. Ramsey Hanafi with the California Employment Lawyers.
Good afternoon.
Hello, my name is Tara Zoomer, and I'm here today because the government is the only institution that citizens have that is big enough and powerful enough to protect their rights. Until this experience, I never knew that companies had the power to take away the rights of citizens through forced arbitration agreements. In March of 2015, I was hired by WeWork as an associate community manager for $42,000 a year, or $82 a day. While the title was vague and the salary was low, I was excited to be part of a growing startup, and I eagerly signed my offer letter. The office leasing company, which includes a keg, amenities, and events on every floor, was valued at $15 billion and growing rapidly. At the time, I didn't realize their rapid growth was due to the free exploited labor of its young workforce. While I enjoyed the mission of the company, I began to notice myself and my coworkers were working 50 or more hours a week, doing mostly menial labor tasks like retrieving mail and changing kegs. Early on, I reported issues of work-related stress, understaffing, and personal cell phone expenses being incurred by employees, and I was met with an all-too-common answer: we're a startup, we're figuring these things out. My many young coworkers were fresh out of college and unaware of labor laws. So over the next few months, I began to build a wage case for myself and other interested employees for our misclassification as salary exempt. I hoped that we would have had a collective chance to be paid back for the work that we had already provided the company. When my manager found out I was starting a case, she told me I should stop talking to other employees about their rights, because their path is their path, and I should let them discover it on their own. I was told my discussions about wages was negative to the work environment, and asked if I wanted to resign. I did not. A few weeks later, a surprise email came from the company headquarters in New York notifying employees that someone from HR and legal would be coming by for 24 hours to have all employees sign new contracts. A conference room was set up with managers, a stack of papers, an empty chair, and a pen. Employees were then called in one at a time to sign all new documents on the spot. When it was my turn, a stack of over 50 pages was placed in front of me, including a new employee handbook, a non-disclosure agreement, and a 9-page arbitration agreement they titled an Employee Dispute Resolution Program. I was told these documents were standard, and they were not. I thanked them and asked them for time to properly review the legally binding pages before signing them, and sensing the agreement was due to my concerted activities, I warned my coworkers of their rights to also refuse. As I feared, the new documents included a 9-page arbitration agreement which waived my rights to a trial by jury and waived my class action claims. In one day, I watched a company take away people's rights to fight as a collective unit for fair wages and working conditions. I emailed the members of the meeting what would happen if I refused to sign these agreements. And I was told that my continued employment was sufficient to constitute acceptance of the new documents. I asked myself why the company even asked employees if their signatures really for their signatures if they really have no choice. I refused to resign and I refused to consent to the new agreements because as a citizen, I never want to relinquish access to my judicial system. I then sent an email titled, "Your Rights at WeWork," to several hundred coworkers, warning them of the rights they were being asked to waive. And on Monday morning, I was fired for failing to provide my signature. My case was filed on Christmas Eve of 2015, and although I successfully refused being forced into an abusive arbitration agreement, a single sentence in my original offer letter was held up in a court of New York. My case should have been tried in the court of law it belongs in the state where I actually live and not 3,000 miles away, by judges not paid for by my former employers, and by a jury of my peers.
If you'd finish up, but if you haven't
yeah.
gone to law school, may I suggest you can do that as an offer?
Maybe. Because this one sentence was included in my offer letter, from the beginning of my employment, I never had a choice. I am here today as proof of the true nature and danger of these agreements. I am fortunate to be educated and have English as my first language, but many in our country are not. And my story is one of many. I urge you to support this bill and reverse the damage being done to citizens through the privatization of the court system, because companies should never have the ability to take away the rights of citizens. Thank you.
Thank you very much. I would say there are some of us in this dais who share that final comment with you. Sir, very briefly, we've gone a little bit over, but if you could keep it short, please.
Thank you. Ramsey Hanafi, speaking on behalf of California Employment Lawyers Association. Choice of forum and choice of law clauses are a growing problem that myself and my colleagues are confronting on the front lines of enforcing California's employment laws. These choice of forum and choice of law clauses are used solely to make it harder for California workers like the brave and courageous Ms. Zoomer to vindicate their state law claims. The arbitration clause enforced against Ms. Zoomer included a one-sentence New York choice of law and choice of forum clause that was enforced in New York against her. Even if an employer agrees to use California's substantive law in another forum, this does not take into account the inconvenience and tremendous additional cost of things like flying the parties and witnesses to other states, assuming witnesses are physically able to even make the trip. Even if the client's attorneys front the costs of the litigation, which is not always the case, witnesses may either be physically unable to go or forcing subpoenaed witnesses to appear in other states will be impossible due to the gray areas involved in out-of-state private arbitrators lacking functional subpoena power over out-of-state witnesses. In our case, increased travel expenses, witness availability, and other costs have already negatively affected our ability to present the claims of Ms. Zoomer and other WeWork employees effectively.
Thank you.
Thank you.
If there are questions, we'll be happy to have you come back and answer those. At this point, just witnesses in support, name and affiliation, please.
Yes, Madam Chair. Elise Sanguinetti on behalf of Consumer Attorneys of California.
In support. Thank you. Other witnesses in support.
Good afternoon. Aaron Lewis for the Consumer Federation of California in strong support.
Thank you. Others in support.
Paul Dubois, the CDRC, in support.
Thank you, sir. Anyone else in support? Any opposition to this item? Please step forward. We're going to have you, if you will, step up. If we need you to come back, we will. Good afternoon, Madam Chamber of Commerce.
Good afternoon, Madam Chair, members of the committee. Jennifer Barrera on behalf of the California Chamber of Commerce. I've already apologized multiple times to the office for being late on our opposition. We got our opposition letter in on Friday, and I also apologize to committee staff. And again, I apologize now. And with those apologies, we are opposed to the bill. We are concerned about the scope of this proposal, which specifies for litigation and arbitration, you can't have a choice of venue or a choice of forum law clause excuse me. From our perspective, this is truly a one-size-fits-all that actually doesn't work. So in a lot of these cases, and I am curious to see with regards to the proponent's case, I haven't found a California court case where when they are analyzing whether or not to apply California law versus a choice of law clause or to apply a choice of law venue, where the courts don't engage in a very factual analysis regarding the bargaining power of the parties, regarding where the witnesses are located, regarding where the documents are located, regarding where the majority of the activities took place. So the court makes that determination based upon the fairness of everything involved, where the court or where the case should be held, regardless of whether it's arbitration or litigation. The court looks at all of those factors to determine where the appropriate forum location should be. Similarly, with the choice of law, California especially is extremely protective of their labor and employment laws, and they're very protective of their consumers as well. And I have also not found a case where they have forced a litigant, a California resident, to have a different choice of law apply to a labor dispute arising in California that doesn't offer the same protections that California law. I haven't found one. I've looked, I will continue to look, but I haven't found one. One of the cases that is cited in the analysis is the Olnick case. And I haven't seen the other cases that are listed, but I will look at those and be happy to get back to members about them. But the Olnick case was involving a highly compensated executive who had an attorney negotiate his contract for over 9 months. And when they were in those negotiations, they agreed that any litigation and choice of law would be New York. This wasn't an unsophisticated party. They had legal representation. And basically, this bill would be able to undermine all those negotiations that they did with an attorney on their behalf and agreeing to the consideration of that contract. It would allow them to get out of it just because they didn't designate California as the venue or California as the choice of law. This bill applies to highly compensated CEOs, professional athletes, employees who may only spend 1 day here in California and yet reside in another state altogether, and would be able to utilize this provision to invalidate choice of law venue, choice of law or venue clauses other than California. So it's not a one-size-fits-all proposal that actually works, and we believe that the discretion that the courts currently utilize to analyze whether or not these provision should be enforced is what we should have continue to go on, because they can look at the individual analysis and determine whether or not it should be California and California law as opposed to another venue that may be more convenient for all the parties involved. For those reasons, we are opposed.
Thank you.
Madam Chair, Chris McKaylee on behalf of the Civil Justice Association of California. We share Ms. Barrera's concerns that she's expressed, and we think that the courts have sufficient power in here to ensure that California consumers or California employees are treated appropriately, utilizing a standard of interest of substantial justice. And I would note that the bill is similar to measures that have been previously vetoed by the current governor and the prior governor. Thank you.
Thank you very much. Other witnesses in opposition, please come forward with your name, affiliation, and position. Very
Madam Chair and Senators, Alex Alanis with the California Bankers Association in opposition.
Thank you. Any other witnesses in opposition? We'll bring it back to the committee. We'll start with Senator Monning and Senator Hertzberg, and then Senator Lim.
Thank you. And I think this may be a question for Ms. Barrera, if you wouldn't mind coming forward. So you raise a concern of highly compensated parties to a contract, maybe represented by lawyers, et cetera. But you made reference that in your review of choice of venue, that the courts will weigh interests, travel miles, sophistication of the parties, et cetera. But isn't it true that if you are a consumer, let's say an employee who signs an arbitration contract at the time of hire, as the earlier witness described, and in that letter of understanding or 90 pages of forms to file, it says arbitration will be in New York, the only way you get a court to review that is you've got to go to court. So how does a a low compensated employee get into the court system for a court to make that determination when they're told you have this binding arbitration, and for you to pursue your arbitration, you've got to go to New York?
I totally understand your question. It's a valid question. You would have to go to court, right? Or you either proceed with the arbitration, which I would consider to be an unconscionable provision of the contract, especially for a California resident, which everything has happened here. But that's the case with regards to, I would suggest, any unconscionable contract provision is if you sign it and you're going to try and enforce the contract, you have to go to court for access. So I would presume that in that situation, just like with litigation or another unconscionable contract provision, you would have to go to court to say, I'm filing my case here in California. The defendant would file a motion to compel arbitration, and at that time, the court would look at the choice of venue provision and say, it's unconscionable, we're not enforcing this arbitration provision with that choice of law or venue. I keep mixing those up. Sorry about that.
Thank you again, and I do think, as you aptly point out, to challenge anything, you have to end up in a court. So even if you're a low compensated employee, that is going to be your pathway. But I think part of the spirit of this legislation is to level the playing field so an employee in an adhesion contract doesn't have to find their way to court, or maybe just determine in an unsophisticated way, the only way I can challenge this is to buy a plane ticket to New York. But question for the author, on the issue of, let's say, more sophisticated parties to a contract. In a contract, my understanding is the parties could agree by contract, not by arbitration agreement, but through an employment contract where they're both represented to where disputes will be resolved in the event of a dispute. How do you answer that question?
I think I have to take another look at it. I mean, again, we've got this narrow CEO, athlete, everybody's represented by a team of attorneys. That seems to make sense. That maybe the bill goes too far in that limited exercise.
Or maybe the distinction is between what's contained in an arbitration agreement versus a contract where both parties are represented by counsel.
It stands alone.
I think I was.
Oh, excuse me, Senator Hertzberg, would you like to proceed?
I'm sorry. I apologize.
Sorry.
Yeah, I was exactly on the same thinking that you were, Senator Monning, and that is, but I looked at the bill, and my read of it is, I mean, some of the toughest contracts ever, terms of negotiating contracts over the years has always been the choice of law, because that sets the rules. You can talk about what you're going to say, but the rules, whether it's international arbitration court or whether it's in what country, it's unbelievably impactful. And in federal courts, this whole issue of choice of law, you've got a federal system, but you choose based upon those factors that you determine venue in, where the reasonableness is of the parties and all of those things. But this says voidable. It doesn't say void. And if you take a look at the cases, you will find, I believe, that voidability is waivable. And so that this 9-month contract with this very rich person, or in the contract that Senator Monning referred to, what lawyers would do is just like we do with Section 1542 of the Civil Code in settlement cases, is we waive, right? So they would say the parties are aware that this is the case, and they've waived, and they've made the conscious choice with the counsel. Same thing happens in marital dissolution cases, where you can waive the continued support. There's a whole history, jurisprudential history about this. So I think, you wanted to put some more definition on it, but I think your word voidable really gets to the difference between the adhesion contract, where you have a pre-printed contract like you had mentioned your testimony before for buying your telephone, which no one's responsible for following because no one is expected to read it, except for you as a lawyer, and versus the negotiated contract. So I think it deals with that, but because this is the toughest issue you always face in contract negotiations, of course, the price.
And, Madam Chair, this is a major difference between the other bills that had been vetoed by the governor, or voidable or just void. And I would suggest that all the members of the committee should pinch themselves that the chamber is arguing for us to go to court, and Mr. Wieckowski is saying, no, let's avoid the charge.
okay. No, that's okay.
Just, it didn't, arbitration does that to us. It's okay. It just.
So are there any other questions? Senator Leno, I believe you had. Very good. Any other questions? All right. Senator, thank you. Senator Wieckowski, if you'd like to close.
I would urge an aye vote, and thank you for your indulgence.
Motion by Senator Monning to Senate Appropriations. Motion is due pass to Senate Appropes. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Anderson? No. Anderson, no. Hertzberg? Aye. Hertzberg, aye. Leno? Aye. Leno, aye. Monning?
Aye.
Monning, aye. Wieckowski?
Aye.
Wieckowski, aye.
All right, that's 5-1. That bill is out. And now we will proceed with the regular or the other order of business, starting in file order with number 5, SB 929 by Senator Vidak. Thank you very much for your patience, and please take a seat. Senator Vidak, you may proceed.
Well, thank you. Good afternoon.
Good afternoon.
Madam Chair and members, Senate Bill 929 would allow individuals who are successful in their petition for the appointment of a neutral third party to act as a conservator to seek reimbursement if the court finds the cost just and reasonable. Current law already allows for reimbursement of any fees and costs associated with the filing of an unsuccessful petition for conservatorship, but does not afford reimbursement to those who are successful in their petition. This lack of reimbursement may deter some family members from exercising their right in court to petition for the appointment of a third party to act as a conservator. SB 929 provides parity for the reimbursement between those who are successful and unsuccessful in their petition before the court. This bill is nearly identical to SB 269, which passed this House last year with unanimous support. Thank you.
Always short and sweet. Very good. Thank you. Witnesses in support.
Larry Doyle on behalf of the Conference of California Bar Associations. We're the sponsors of the bill. Senator Vidak has expressed the bill very well. It removes an impediment to the protection of conservatees by equalizing the situation. We have right now, if you petition for yourself to be appointed as a conservator and you're successful, you can get reimbursed. If you petition for a third party to be appointed as a conservator or yourself and you fail, you can still be reimbursed if the court finds that it's done in the best interest of the conservatee. If you petition for the appointment of a neutral third party for reasons like, say, you live in a different part of the state, but you were successful in getting that person appointed, you can't get reimbursed under the law. It makes no sense to have that distinction, and we're just trying to level the playing field and make sure that people are protected.
Thank you very much. Any other witnesses in support? Any witnesses in opposition? Any questions from the members? Motion by Senator Morlock. Any other questions? No? Thank you. I think this is just a common sense. What's good for the goose is good for the gander. And with that, this is a motion by Senator Morlock to pass to the Senate floor. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Aye. Anderson, aye. Hertzberg? Aye. Hertzberg, aye. Leno? Aye. Leno, aye. Monning? Wieckowski?
Aye.
Wieckowski, aye.
All right, that's 6-0. We will keep the roll open for the absent member. Thank you very much, Senator Vidak. Next, we have Senator Block. We'll do Senator Morlock at the end because he's a member of the committee. Senator Block, we have dispensed with file item 9 on the consent calendar, so it's file item 8, SB 1257.
Thank you, Madam Chair. SB 1257, first of all, I'd like to start by accepting authors' amendments that are proposed on pages 6 and 7 of the committee analysis. Currently, the California State Bar requires applicants taking the bar exam to fulfill certain requirements and meet specific conditions in order to sit for the exam. These requirements include passing a moral character background check, having no outstanding family support, compliance issues, and passing various early examinations. Due to the rigorous class schedule during law school and limited extracurricular activities, law school students rarely have time for exposure to a wide range of legal fields and usually acquire little or no hands-on experience in any field before entering the practice. SB 1257 would expand a new lawyer's experience in the legal field by requiring an applicant for admission to the California State Bar to complete 50 hours of supervised pro bono work related to the legal profession prior to taking the bar exam. This requirement would supplement the applicant's legal education with practical legal work experience. It would also provide thousands of underserved Californians with quality supervised pro bono representation. In addition, the exposure to the representation of low-income clients might also attract more new attorneys to practice in high-need but relatively low-paid fields of law. After completion, the measure requires an applicant to submit a form to the State Bar confirming 50 hours of pro bono service with random audits by the State Bar. This idea has been discussed by the Bar for many, many years, by the legal community for many years, and it's time to bring it forward and make it law. There's no known opposition, and I respectfully ask for your aye vote.
Thank you, Senator Block. Any witnesses in support? Any witnesses in opposition? Any questions from the members? Senator Leno and then Senator Monning.
How did you land on 50 hours?
Well, the Bar Association did study this issue in 2013, came up with some recommendations that were never enacted, and those recommendations had 50 hours in them. That's what we use. Frankly, it is a somewhat arbitrary sum.
Thank you.
Thank you. Senator Monning.
I just want to thank the author for bringing this forward. I think it's long overdue, and I think many law students today do have opportunities to engage in clinics and community-based service, and to quantify that and give all students, I see it really as an opportunity. And in terms of the hour question, law school was a while ago, but it's pretty rigorous, so I think 50 hours is a good start. It may be in the future people think students could absorb more, but this seems like a good starting point. But I just want to applaud the author. And Madam Chair, I'm glad to move the bill at the appropriate time.
All right. Thank you very much. Senator Morlock.
Thank you, Madam Chair. Senator Block, I'm having difficulty getting it. So maybe all law students are wealthy and can work for free. They're not being compensated. Would they do this off hours, or how would they, I'm just trying to figure out how, are they being asked to take a week vacation to put in 50 hours? How does?
Well, it's 50 hours over the course of their legal education prior to taking the bar exam. It could be as little as 1 hour a week for 50 weeks. So it's really not a rigorous standard. If they're working while they're going to law school, some do, some don't. This 1 hour a week could fit during their work time. And by the way, the genesis of this bill was during a budget sub 1 hearing. You sit as my vice chair on sub 1, when we had a funding request from Hastings Law School to get more funding. And I made the comment, I'm reluctant to give more funding to law schools because there's an overabundance of lawyers. To which the law school replied, well, but we need more lawyers in certain areas. There are certain underserved areas. So I said, well, there have been underserved areas for 10, 20, 30, 100 years now. Why aren't they being served? And we started to discuss, well, students tend to go, they gravitate to the higher paying legal professions, often with big corporations. And that's when this idea kind of came to get students a taste of working with underserved, which for many students can be very exciting, and at the same time provide them with a greater range of experience and some practical. When I got out of law school, I had no practical experience prior to walking into court my first time. I didn't know which seat I was supposed to sit in. And beyond that, of course, serving the underserved. And with supervision, you have one or two attorneys who are supervising, they can greatly expand their reach by having several people they're supervising. So I hope you'll see the wisdom of this.
And would an intern program qualify?
Some details still need to be worked out as we move through. I would certainly want to accept that, yes.
All right, thank you, Senator. Thank you, Madam Chair.
Thank you. And I, too, think this is an excellent idea. And law school, for me, is a long time ago, but it is a very rigorous experience, and particularly if you have to work part-time in the process. But nonetheless, having some of that experience is helpful. My concern, which I've articulated, is that this be legitimate time spent, that there be legitimate oversight and accountability, and I appreciate your willingness to work with us on that. And I think there are legitimate questions as you move the bill. So we do have one last question from Senator Leno.
I see, and we've already discussed it, needs to be supervised, but the claim that 50 hours has been attained would be self-documented?
Kind of like continuing legal education. It is self-documented, but with the State Bar Association doing random audits to try to enforce compliance. And additionally, these students, in order to take the bar exam, have to pass moral character background checks. And we have to assume, with hopefully some degree of certainty, that students are being honest in their reporting.
Thank you.
All right, very good. I assume that's your close. We have a motion. The motion is due pass to the Senate floor. Please call the roll.
The motion is due pass as amended to the Senate floor. Jackson?
Aye.
Jackson, aye. Morlock? Aye. Morlock, aye. Anderson? No. Anderson, no. Hertzberg? Leno? Aye. Leno, aye. Monning? Aye. Monning, aye. Wieckowski? Aye. Wieckowski, aye.
All right, that bill has 5 votes, 5-1. We will leave it on call for the absent member. Thank you,
Madam
Senator
Chair.
Block. And next up, we have Senator Stone. Is he here? Yes, okay. File item 10, SB 1306,